This is Dr. David Schein, and welcome to Business Law 101. And of course, the way people acquire a trade secret in many cases is kind of a hint that people knew that it was a trade secret and that they shouldn't have been doing it. There's a very famous case in this area, and it's the Pepsi-Cola case. So what happened was there was the secretary figured out how to get to the famous formula for Pepsi-Cola. And she contacted some people in, I'm sorry, I gave it backwards. So you had a secretary at Coca-Cola who contacted the people at Pepsi-Cola, the #2 cola nationally, and said, hey, I can get you this formula for the original Coca-Cola, and you can be really cool guys and get the original formula, which has been protected for 100 years as a trade secret. So what happened is that Pepsi-Cola, I think, were first of all probably insulted, probably said, well, wait a minute, we think our Pepsi-Cola product, part of our strength is that it doesn't taste like Coca-Cola. It tastes different, and that's a positive, and we have our own trade secret. And #2, we feel like we're being set up or this person's engaged in criminal conduct. So what the Pepsi-Cola people did is they contacted the FBI, which is what they should have done. And they said to the FBI, hey, this person is trying to sell us, illegally sell us the original Coke formula. And so when she showed up to make her secret exchange for $10,000, she was surprised to meet an FBI agent who placed her under arrest. But some of the best known trade secrets are the formula of original Coca-Cola and the 12 magic herbs and spices of Kentucky Fried Chicken.
So it's an NDA not enough?
Well, the NDA normally includes a trade secret prohibition. It's not a question of enough. It's a question that a lot of people are greedy and will take advantage of their position to exploit the trade secrets of where they're working. Does that answer your question? Does that address what you're talking about?
Yes. Thank you.
Okay. And in modern confidentiality, most companies today are using a modern confidentiality trade secret agreement, the NDA, and it includes specific reference to the Defense of Trade Secret Act, the 2016 Act I mentioned a minute ago, to just defines a lot of the different ways of confidential information. Now, a lot of confidential information is not a trade secret, but it's things, lists of customers, things like that, and you're not supposed to be taking that information from your current employer. Now, keep in mind that there is a common law right on the part of businesses to own their intellectual property. So even if you don't sign a confidentiality NDA, if you steal confidential information or trade secret information of your employer and try and peddle it to somebody else, you are indeed committing at least a tort, if not a crime. So if you take things that you're not supposed to, if you take it from somebody else who took it who was not supposed to, if there was an accidental disclosure trade secret, then you're still not entitled to it. And someone else who had a breach of confidentiality. So these are fairly similar ones, but the point is fairly consistent. Remember, uniform protection of the trade secrets. And the injunction to prevent disclosure. So you find out somebody's got something that they should not have, you can go to court to get an injunction to keep them from disclosing it. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, we invite you to subscribe on your favorite platform.